In this lecture, we shall discuss the enforcement of judgments by a writ of Fieri Facias within the context of the civil procedural rules in Ghana. Now, enforcement of judgments by a writ of Fieri Facias in Ghana. This discussion is important because there are times when a plaintiff commences an action in the court of law. The court would grant judgment in favor of the plaintiff to recover an amount of money from the defendant, and the plaintiff will be wondering how he can recover the money from the defendant, especially when the court orders that the defendant should refund to the plaintiff an amount of money, and the defendant should refund to the plaintiff an amount of money, and the defendant still refuses to pay that amount of money to the plaintiff. So let us say that the High Court has ordered that the defendant should pay an amount of 1 million Ghana cedis to the plaintiff, and the plaintiff has refused to pay, and the defendant has refused to pay the money. How can the plaintiff take any steps towards recovering the money from the defendant? That is what we shall discuss in this lecture. The starting point is Order 43, Rule 1 of the CR 47. It is headed Enforcement of Judgments for Payment of Money. In other words, if you have judgment against a person, like the example I just gave, and it is a judgment for the payment of money, in that the defendant has been ordered to pay an amount of money to the plaintiff. That is what Order 43 helps us in understanding. Order 43 Rule 1 reads as follows, and I quote, "Subject to these rules, a judgment or order for the payment of money, not being a judgment or order for the payment of money into court, may be enforced by any one or more of the following means. A. Writ of Fieri Facias. B. Garnishee proceedings. C. Charging order. D. Appointment of a receiver." And there's also a provision for E. The critical point to be noted about Order 43 Rule 1 is first of all that it relates to the enforcement of judgment for the payment of money. If the judgment you have is for the recovery of possession, you don't have any business referring to Order 43 Rule 1. If, for example, the judgment you have is for the recovery of possession of an immovable property, like a land or a house, you don't have any business dealing with Order 43 Rule 1. Order 43 Rule 1 deals with judgments for the payment of money. And Rule 1 even has clearer language to the effect that a judgment or order for the payment of money, not being a judgment or order for the payment of money into court, may be enforced by one or more of the following means. It means that if you want to enforce a judgment for the payment of money into court, you don't have any business dealing with Order 43 Rule 1. Order 43 Rule 1 deals with a judgment or order for the payment of money, which is not a judgment or order for the payment of money into court. So it can apply to a judgment or order for the payment of money to an individual. For example, if I bring the action against you and the court has ordered you to pay money to me, then I can refer to Order 43 Rule 1, because the money you've been ordered to pay to me is not a judgment or order for the payment of money into court. It is a judgment for the payment of money to an individual, me the plaintiff. So for me, I can come under Order 43 Rule 1. Now take a look at Order 43 Rule 1 again. Our main discussion in this lecture is to deal with the Order 43 Rule 1A, and it reads as follows. Subject to these rules, a judgment or order for the payment of money, not being a judgment or order for the payment of money into court, may be enforced by any one or more of the following means. A writ of Fieri Facias, which shall be the focus of our discussion in this lecture. Now look at Order 45 as well, Rule 1. Order 45 Rule 1 also provides that a judgment or order for the payment of money may be enforced by a writ of Fieri Facias, what we call a writ of Fieri. So in the remaining part of this lecture, I shall be referring to the Fieri Facias as Fieri. Now, under 43 Rule 1, which generally deals with the enforcement of judgment for the payment of money, provides that you may enforce the judgment by a writ of Fieri Facias. Then Order 45 Rule 1 makes it clearer by indicating that a judgment or order for the payment of money may be enforced by a writ of Fieri Facias. Take note, it didn't say shall. It is not by force for you to enforce a judgment for the payment of money by a writ of Fieri Facias. That is why the rule says that you may enforce it by a writ of Fieri Facias. A writ of Fieri. Now, how do we even execute a judgment by a writ of Fieri? If the registrar issues a writ of Fieri for the execution of a judgment for the recovery of money, how can it be executed for you to get your money back? Because we've been told that a judgment or order for the payment of money may be enforced by a writ of Fieri Facias. Is it that when the writ is issued, you get your money? How does the writ of Fieri enable you to get your money back? Look at Order 44 Rule 1, Sub Rule 2 of the High Court Civil Procedure Rules 2004 CI 47. It provides as follows, and I read. Where a writ of Fieri is issued, it shall be executed by the seizure and sale of the debtor's property sufficient to satisfy the amount of the judgment debt, together with post-judgment interest at the appropriate rate until payment and the costs of the execution. Again, where a writ of Fieri Facias is issued, it shall be executed by the seizure and sale of the debtor's property, sufficient to satisfy the amount of the judgment debt, together with post-judgment interests at the appropriate rate until payment and the cost of the execution. What do we get from Order 45 Rule 1 Sub Rule 2 of the CI 47? It says that when a writ of Fieri Facias is issued, it's telling us how we can execute that particular writ. That it shall be executed by seizing property belonging to the judgment debtor, that is the one against whom judgment has been given for him to pay money to a particular person. So it shall be executed by the seizure and sale of the debtor's property. It means that if you, a defendant, have brought an action against you and you have been ordered to pay an amount of money to me, the plaintiff, and you have not paid, and then I have taken steps and the writ of Fieri has been issued, I shall execute that writ of Fieri by seizing your property, selling it, and then I will take an amount from the proceeds of the sale that will be enough to not just pay the judgment debts, but also post-judgment interests at the appropriate rates. And even the cost we even incur in the execution, we shall also take that money out of the proceeds of the sale. For example, if you incurred some costs in bringing towing cars to come and tow your cars from your house, we will take all those costs we incurred and give you the balance, if there's any balance. That is how a writ of Fieri is to be executed. It says that under 45 rule 1 sub rule 2, where a writ of Fieri is issued, it shall be executed by the seizure and sale of the debtor's property, sufficient to satisfy the amount of the judgment debt, together with post-judgment interest, at appropriate rates until payment and the cost of the execution. How do we go ahead and put this writ into effect? How do we go ahead and seize the properties? How do we go ahead and put the writs into effect? Look at Order 45 Rule 4 of the High Court Civil Procedure Rules CI 47. The heading of that particular rule even gives an indication that you will be told how we can put the writ of Fieri into effect. Order 45 Rule 4 reads, methods of putting writ into effect. It is going to tell us how we can put this writ of Fieri into effect. If you are saying that it shall be executed by the seizure and sale of the debtor's property, how do we seize a landed property? How do we seize it? You can't carry land and take it to the court. How do we seize landed property? So how do you put this writ into effect? Because we've been told that it shall be executed by the seizure and sale of the debtor's property. So how is the seizure carried out? Look at Order 45 Rule 4 of the CI 47. Order 45 Rule 4 Sub Rule 1 reads as follows. Subject to the other provisions of this order and to the provisions of any other enactment, a writ of Fieri shall be put into effect. A. In respect of any movable property in the possession of the judgment debtor by actual seizure, the property being kept in the custody of the registrar until sale. What we are being told under the 45 Rule 4 Sub Rule 1A is that if we are supposed to execute a writ of Fieri and we are supposed to seize any movable property, we shall execute the writ, for example, if it's a car, by taking an actual seizure of the car, and the car will be kept in the custody of the registrar until the sale has been carried out. That is how we shall execute the writ of Fieri in respect of a movable. So if judgment has been given against you, you were supposed to pay an amount of money. You don't pay. If a writ of Fieri is issued and we see you with a vehicle, the registrar can take steps to ensure that it is seized from you, because the rule says that in respect of any movable property in the possession of the judgment debtor by actual seizure, and won't give it back to you, the property will be kept in the custody of the registrar until the sale. What if whatever we have to execute it against is money or negotiable instruments? Look at Order 45 Rule 4 Sub Rule 1B of the CI 47. It reads as follows. In respect of any movable, any money or negotiable instruments, I'll take it again. In respect of any money or negotiable instruments by actual seizure, and the money or instruments being deposited in court by the registrar and held subject to the further order of the court. So if what we are supposed to execute the writ of Fieri against is money or negotiable instruments, we shall seize that money or negotiable instruments and deposit same into court. And we shall hold it over there until any further orders of the courts. But what if the judgment is to enforce the essence of the writs is to enforce a judgment and we have to seize immovable property? Immovable property that belongs to the judgment debtor. Immovable property. Look at Order 45 Rule 1, Order 45 Rule 4 Sub Rule 1E. It reads as follows. In respect of any immovable property or any interest in immovable property, whether at law or in equity, by a written order prohibiting the judgment debtor from alienating the property or any interest in the property by sale, gift, or in any other way, and prohibiting all persons from receiving it by purchase, gift, or otherwise. And the registrar may also, by direction of the court, take and retain actual possession of the property. What do we mean by this under the 45 Rule 4 sub Rule 1A? That if you are supposed to execute the writ of Fieri, remember you've been told already that it shall be executed by seizing the property. And now you are trying to understand how we can seize a property if it's about land. So that if it is in respect of any immovable property or an interest in immovable property, whether at law and equity, we shall execute the writ by a written order. The written order will be prohibiting the judgment debtor. And will be telling him that you are prohibited from today from alienating the property or any interest in the property, whether by sale, by gift, or in any other way. In other words, if we come and we attach that building pursuant to the writ of Fieri, when you attach your house, you'll be given a written order which will prohibit you, the judgment debtor, from alienating the property. So you can't sell it, you can't give it out as a gift, you can't alienate it in any way, because remember, the essence of the writ of Fieri is that we are supposed to attach, sell, and pay the money to the judgment creditor. If we don't put this over there, the moment the property is attached, somebody will go and sell it and overreach you. So the law says that in respect of an immovable property, we shall put the writ into effect by a written order prohibiting the judgment debtor from alienating the property or any interest in the property by sale, gifts, or in any other way. So from the time we attach the property, you should not go ahead and sell it. You should not go ahead and give the house out as a gift or alienate it in any other way. In fact, it's not only the judgment debtor that is prohibited. The law proceeds that prohibiting all persons from receiving it by purchase, gift, or otherwise. So the prohibition is against the judgment debtor. The judgment debtor, you are prohibited from alienating it by way of a sale, gift, or in any other way. Not only is the judgment debtor prohibited, you, the purchaser, who want to go and buy a property. So if you are aware that property has been attached, belonging to somebody against whom you have obtained judgment against. So you know, for example, Kofi went to court with Amma, and Amma obtained judgment against Kofi. And so Kofi's house has been attached, and they're about to sell it. If you, the purchaser, you also go and buy it, we are saying that the law is also prohibiting you from receiving it by purchase, even the gift. You are prohibited from receiving it as a gift. So if it is in respect of an immovable property, or the 45 Rule 4 1E is saying that in respect of any immovable property or any interest in immovable property, whether at law or in equity, by a written order prohibiting the judgment debtor from alienating the property or any interest in the property by sale, gift, or in any other way, and prohibiting all persons from receiving it by purchase, gifts, or otherwise. And the registrar may also, by direction of the court, take and retain actual possession of the property. If the registrar is given a direction by the court, he can go and also take possession of the immovable property in itself. So take note of this. This is very important, that if you have to execute a writ of Fieri, but it's against an immovable property. You can't go and carry the property and take it to the court. So we shall give you a written order prohibiting the judgment debtor from alienating the property or any interest in it, whether by will of a sale, gift, or otherwise, that you shall not alienate it. Not only is the judgment debtor prohibited, any purchaser or person claiming to receive it under a gift due to you are also prohibited. Now, take a look at this case of ACA versus Ghana Commercial Bank, reported in 2013-2014, 2 Supreme Court of Ghana law reports, page 1157, where it was held as follows. That a settled practice in execution of judgment is that the issue of a writ of Fieri takes place on its being sealed at the registry of the court, which is executing the judgment on behalf of the judgment creditor. Execution of the writ by a sheriff involves the attachment of the property, the subject matter of the execution. Execution commences with the filing of the entry of judgment. A writ of Fieri, being a writ of execution, is part of the execution process used to seize or attach the property of a judgment debtor. Hence, once the property in question is seized, the writ of Fieri is executed. Once the property in question is seized, the writ of Fieri is executed. I'll take the last portion once again. Execution commences with the filing of the entry of judgment. A writ of Fieri, being a writ of execution, is part of the execution process used to seize or attach the property of a judgment debtor. Hence, once the property in question is seized, the writ of Fieri is executed. So, how do we execute the writ of Fieri if it's in respect of an immovable property? Take note, we execute it by serving a written order prohibiting the judgment debtor from alienating the property or any interest in the property by sale, gift, or in any other way, and also prohibiting all persons from receiving it by purchase, gift, or otherwise. What if you have obtained judgment against a particular person and then you want to attach some shares he has in the company? So let's say he doesn't have a car, he doesn't have a house, but you know he has shares in a particular company. Can you also execute the writ of Fieri against those particular shares? The answer is under Order 45, Rule 4, Sub Rule 1D. And it reads as follows. In respect of shares in any body corporate, by a written order prohibiting the person in whose name the shares are held from making any transfer of the shares or receiving payment of any dividends of the shares, and prohibiting the manager, secretary, or other proper officer of the body corporate from making such payment until such further order. So if I want to recover money from you, apart from your land, apart from your car, the rules permits me to also attach shares that you have in the company. And I can attach those shares because Order 45 Rule 4 1D says that in respect of shares in any body corporate, by a written order prohibiting the person in whose name the shares are held from making any transfer of the shares or receiving payment of any dividends of the shares, and also prohibiting the manager, secretary, or other proper officer of the body corporate from making such payments until such further order. So you see, what we've done so far is that we have seen how we can execute a writ of Fieri if it's in respect of a movable property. the rule say we shall execute it by what? Actual seizure of the property. If we want to execute the writ and it's in respect of money or negotiable instruments, by actual seizure and the money or the negotiable instrument being deposited in court by the registrar and held over there subject to further orders of the courts. If you want to execute it in respect of a body corporate, then by a written order prohibiting the person in whose name the shares are held from making any transfer of the shares or receiving payment of any dividends on the shares. So that if you have shares in the company, I can serve you with a written order that from today, don't transfer the shares. From today, don't receive any dividends from the shares because you are owing me. And I've obtained judgment. And I have attached those shares. So I give you a written order prohibiting you from alienating the shares or even receiving payment of dividends. I won't serve you alone. I'll also serve the manager, secretary, or other proper officer of the body corporate from making any such payments until such further orders from the court. So now your shares will be there. You can't transfer, you can't receive dividends. Yes. That is how we can put the writ into effect if it's in respect of shares a person has in the body corporate. What if it's about land? Order 45 Rule 4(1)(e) says that in respect of any immovable property or any interest in immovable property, whether at law or in equity, by a written order prohibiting the judgment debtor from alienating the property or any interest in the property by sale, gifts, or in any other way, and prohibiting all persons from receiving it by purchase, gifts, or otherwise. So if it's immovable property, we shall give you, the judgment debtor, a written order prohibiting you from alienating it, and we shall prohibit even the purchaser or the person receiving as a gift from receiving it. So we have seen in Aka versus Ghana Commercial Bank 2013-2014 that execution commences with the filing of the entry of judgment, and a writ of fieri being a writ of execution as part of the execution process used to seize or attach the property of a judgment debtor. Hence, once the property in question is seized, the writ of fieri is executed. What if the property you want to attach is property that a person is holding in his capacity as a public officer? Look at Order 45 Rule 4 Sub-Rule 3. It reads as follows. Subject to any enactment, property in the custody or under the control of any public officer in the officer's official capacity is liable to attachment in execution of a judgment or order with notice to the Attorney General, and the order of attachment shall be served on the public officer. Again, subject to any enactment, property in the custody or under the control of any public officer in the officer's official capacity is liable to attachment in execution of a judgment or order with notice to the Attorney General, and the order of attachment shall be served on the public officer. But there's one question that is important to address. We know we use a writ of fieri if we want to recover money from a person against whom judgment has been given against. So that, for example, if we have a situation whereby I have obtained judgment against a defendant, he was supposed to pay me, the plaintiff, 1 million Ghana cedis, and he has refused to pay. And the rule says that I can go ahead and issue a writ of fieri to attach his properties to the extent and sell them for an amount that I will use to pay myself for the judgment debts. But I have this question. We've been told that you can execute the writ of Fieri if it's in respect of a movable by actual seizure of the movable, and if it's an immovable property by a written order prohibiting the judgment debtor from alienating the property, and also prohibiting all persons from receiving it by purchase, gift, or otherwise. Now my question is this: can a person go ahead and attach immovable properties even when the judgment debtor has movable properties? That you are a person, I've obtained judgment against you, and then I want to execute the judgment because you were supposed to pay me 1,000,000 cedis and you have not paid that amount of money, and I've caused a writ of Fieri to be issued. Can I, as a person, go ahead and then attach your landed properties like your car, like your house? Landed properties, not car. Your house. Landed property like your house. Can I go ahead and attach a landed property like your house, even though you have movables like a car? That is what we must address. Can we go ahead and seize immovable properties, even though the judgment debtor has movables that will be sufficient to satisfy the judgment debts? The answer to this question is under Order 44, Rule 2, Sub 3. Order 44, Rule 2, Sub 3 of the High Court Civil Procedural Rules 2004 CI 47. It reads as follows: the immovable property of a judgment debtor shall not be levied in execution if the judgment debtor shows that the judgment debtor has sufficient movable property within the jurisdiction to satisfy the judgment or order and costs. Again, the immovable property of a judgment debtor shall not be levied in execution if the judgment debtor shows that the judgment debtor has sufficient movable property within the jurisdiction to satisfy the judgment or order and costs. So the rule is giving us an indication that if you've gone ahead to go and attach a landed property, we shall not proceed with the execution if the judgment debtor shows that he has sufficient movable, like cars, within the jurisdiction that will be sufficient to satisfy the judgment or order and costs. Now, it is important that I make reference also to one of the best civil procedure books in Ghana, which has been authored by a lawyer in Ghana in the person of Bobby Banson. So the book I'm referring to is Civil Litigation in the High Court of Ghana, authored by Robert Smith Law Group, Bobby Banson, lead author. I'm making reference to the first edition, which was published in 2022. And take note that this recording is being made in 2023. So the book is quite recent. And I also make reference to a statement in the book that will throw more light on this Order 44, Rule 2, Sub 3, that says that the immovable property of a judgment debtor shall not be levied in execution if the judgment debtor shows that the judgment debtor has sufficient movable property within the jurisdiction to satisfy the judgment or order in cost. Now, I'm making reference to this book of Civil Litigation in the High Court of Ghana, authored by Robert Smith Law Group, Bobby Banson, lead author. I'm making reference to the first edition, and I'm making reference to page 207. This is what the book says, and I quote: "The general rule is that the movable properties of the judgment debtor must be attached and sold in satisfaction of the judgment debt. Where the movable properties of the judgment debtor are not able to satisfy the judgment debt, then the immovable properties of the judgment debtor can be attached and sold. However, where the judgment creditor attaches the immovable properties of the judgment debtor first, the burden is on the judgment debtor to demonstrate that he has sufficient movable properties to satisfy the judgment debt, for which reason the immovable properties ought to be discharged from attachment. If the judgment debtor does not provide any movable properties, the execution shall not be set aside." Let's take a look at this order 44, rule 2, sub rule 3 again. Now I'm back to the CI 47. It says that the immovable property of a judgment debtor shall not be levied in execution if the judgment debtor shows that the judgment debtor has sufficient movable property within the jurisdiction to satisfy the judgment and order in relation to costs. Now, we are being told on who the burden lies to show that you have movable properties. So if I have attached your immovable property, if the judgment debtor, you must come and demonstrate to the court that you have sufficient movable property within the jurisdiction to satisfy the judgment or order in costs. And that's what we are being told on page 207 of the book titled Civil Litigation in the High Court of Ghana, authored by Robert Smith Law Group, at page 207, where we're told that, however, where the judgment creditor attaches the immovable properties of the judgment debtor first, the burden is on the judgment debtor to demonstrate that he has sufficient movable properties to satisfy the judgment debt, for which reason the immovable properties ought to be discharged from attachment. If the judgment debtor does not provide any movable properties, the execution shall not be set aside. Again, if we look at the case of Ghana Commercial Bank versus Eastern Alloys, reported in 2012, 2017, 2018, to Supreme Law Report of Ghana at page 793. Ghana Commercial Bank versus Eastern Alloys, reported in 2017, 2018, to Supreme Court Law Report of Ghana at page 793. This is what the case says, and I quote: "Wisdom and prudence requires that the judgment debtor, within whose knowledge the existence of movable properties exists, and for whose benefits the said execution of the movable property stands, the debtor must at the earliest opportunity, thus the execution process have commenced or even anticipated, bring this information to the attention of the judgment creditor and the deputy sheriff." So, the judgment debtor, so that's the end of the quote in Ghana Commercial Bank versus Eastern Alloys, 2017, 2018, to Supreme Court Law Report of Ghana at page 73. That you, the judgment debtor, it is for your benefit that the execution will stand if we sell your movable property. So if I've attached your immovable, your land, then you have the burden to ensure that you will come and bring it to my attention that you have these cars over here. I should come and sell it. Other than that, you're in trouble. So that is as far as the writ of Fieri is concerned. We have seen another 45 Rule 3 that if it's a judgment for the payment of money, not being a judgment for the payment of money into court, we can enforce it by a writ of Fieri. We have been informed another 45 that where a writ of Fieri is issued, it shall be executed by the seizure and sale of the debtor's property sufficient to satisfy the amount of the judgment debt, together with post-judgment interest at the appropriate rate and to payment in the course of the execution. We've also been told that if we want to put the writ into effect, we put it into effect if it's a movable by what? Actual seizure, but if it's an immovable by a written order prohibiting the judgment debtor from alienating it. Not only the judgment debtor is prohibited, any person from also acquiring an interest in it. Now I'm interested in this written order. How do we serve this written order if it's on an immovable property? So, if I have a land, and then you say that you want to attach this particular building, this writ of Fieri, we have been told that you shall put it into effect by a written order. Why are you going to put that written order? Are you supposed to give it to me? Are you supposed to post it on the land? Are you supposed to put it at the court? How are you supposed to serve this written order? So, the answer to this question is very critical. Other than that, you've only read in the rules that you are supposed to serve a written order. But how are you supposed to serve the written order? The answer is in Order 45, Rule 5 of CI 47. It reads as follows. Order 45, Rule 5 of CI 47, Sub Rule 1. It is headed Service of Prohibitory Orders. And this is what it says. In the case of any movable property not in the possession of the judgment debtor, an office copy of the order referred to in Rule 4 1C shall be delivered to the person in possession of the property. In other words, if it is a movable property, but it is not in the possession of the judgment debtor. So, for example, if it's a vehicle, but it is not in the possession of the judgment debtor, but maybe it is at a garage, the rule says that we can serve an office copy of the order referred to in Rule 41C to be delivered to the person who is in possession of the movable property. That, my friend, do not deliver this property to this person, do not alienate it. We shall deliver a copy to that person. What if it is in the case of shares in the body corporate? You remember we dealt with it. That if it is shares you have in the body corporate, we can also serve a written order prohibiting the transfer of the shares. You remember? Now look at how we serve that written order when you want to prohibit the transfer of shares under the 45 Rule 5 of CI 47. It reads as follows. In the case of shares in any body corporate, an office copy of the order referred to in Rule 41D shall be delivered to or served upon the manager, secretary, or other proper officer of that body corporate. So if it is a case of shares and I want to prohibit the alienation, I shall deliver a copy of the order on the manager, secretary, or other proper officer of that body corporate. What if it is in respect of an immovable property? Immovable. Order 45 Rule 5 of CI 47 reads as follows. In the case of immovable property or any interest in it, a copy of the order referred to in Rule 41E, certified by the registrar, shall be delivered to the judgment debtor, or if the judgment debtor cannot be found, shall be delivered to some outdoors person at the judgment debtor's last known place of abode or business, to be given to the judgment debtor, or in case that delivery cannot be made, shall be affixed to a front door of the court building, of the courtroom from which the writ of Fieri was issued, and unless in the same court building, to the door of the district court nearest to the immovable property in question. Then we proceed as follows. Order 45, Rule 5, Sub Rule 4. A similar copy of the order referred to in Rule 41E shall also in every case be posted on or affixed to some conspicuous part of the immovable property in question. Let me explain that. So I'm going to explain Order 45, Rule 5.3 and 45, Rule 5.4. Order 45, Rule 5.3 explains as follows. That these prohibitory orders, remember we said for Fieri, if it is in respect of an immovable property, we shall give you a prohibiting order, prohibiting you from alienating, from giving it out as a gift, and also prohibiting somebody from even purchasing it. Remember that provision. How do we serve it? If it is the case of an immovable property or any interest in it, a copy of that prohibiting order that has been certified by the registrar, it shall be delivered to the judgment debtor. But sometimes we know some people will be running away. If it cannot be found, it shall be delivered to some outdoors person at the judgment debtor's last known place of abode, to be given to the judgment debtor. Or in case that delivery cannot be made, we shall affix to a front door of the court building of the court from where the writ of Fieri was issued, and unless in the same court building, to the door of the district court nearest to the immovable property in question. So it means that we can give it to you, the judgment debtor, that we are prohibiting you. If we can't find you, we can give it to an adult person at the judgment debtor's last known place of abode for him to give it to the judgment debtor. That inform him that we are prohibiting him from selling house number 5. But in case we can't get any outdoors tool, we shall affix to a front door of the court building of the court from which the writ of Fieri was issued, and unless in the same court building, to the door of the district court nearest to the immovable property in question. But the interesting provision is Order 45, Rule 5, Sub Rule 4. It says that a similar copy of the order referred to in Rule 41E shall also in every case, be posted on or affixed to some conspicuous part of the immovable property in question. So this prohibiting order, if it is in respect of an immovable property, in every case, you must make sure that you have affixed a copy of that order also on a conspicuous part of that immovable property in question. It is good. It's mandatory that in every case, make sure, so usually you see attachments, then we put it over there on the building. So everybody around will see that your house has been attached, you are owing money, you've not been paid. You are owing somebody money, you've not paid. So they can't attach your property. So that is Order 45, Rule 5, Sub Rule 4 of CI 47. That a similar copy of the order referred to in Rule 41E shall also in every case be posted on or affixed to some conspicuous part of the immovable property in question. Now the interesting question that arises. We've been told that a writ of Fieri can be executed by giving a written order prohibiting the person from alienating the property. Not only the person, prohibiting other persons from also alienating, from also buying the property. But what if after you've given me the prohibiting order, I still go ahead because remember, the land documents are in my name. Lands Commission is my name. And I'm going to sell it to somebody during the period that the building has been attached. What will be the consequence of it? Yes, you've given me the prohibiting order, but I've gone ahead to still sell it. I've taken money. What is the consequence of it? The answer to this question is under Order 45, Rule 6 of the CI 47. And it reads as follows. It is headed Unauthorized alienation during attachment void. This is the language of Order 45, Rule 6 of CI 47. It reads as follows, and I quote. After an attachment has been made by actual seizure or by a written order duly delivered, served or posted in accordance with Rule 5, any alienation without leave of the courts of the property attached, any alienation without leave of the court of the property attached, whether by sale, gift, or otherwise, and any payment of the debt, dividends, or shares to the judgment debtor during the continuance of the attachment shall be null and void, and the person making the alienation or payment shall be liable to committal for contempt of court. This is a very instructive provision in the CI 47. That after an attachment has been made by actual seizure, so remember we said that if it's a movable, you can execute it by actual seizure. But we mentioned that if it's an immovable, you can give a written order prohibiting the alienation. And remember we said if it's in respect of shares, you can give a written order prohibiting the alienation of the shares or even paying of dividends. Now look at what Order 45 Rule 6 is saying. That after an attachment has been made by actual seizure or by a written order duly delivered, served or posted in accordance with Rule 5, any alienation without leave of the court of the property attached, whether by sale, gift, or otherwise, and any payment of the debt, dividends, or shares to the judgment debtor during the continuance of the attachment shall be null and void. Not only will it be null and void, and the person making the alienation or the payment, so you the one who did the alienation or the one who made the payment, you shall be liable to committal for contempt of court. So two consequences. One, the transaction itself will be null and void, and also the person who made the alienation to shall be liable to committal for contempt of court. So that is what the consequence would be if you alienate property after it has been attached pursuant to a writ of fieri being executed. If you alienate it, the consequence is that the alienation itself will be null and void, and the person making the alienation or the payment will be liable to contempt of court. Now, take note that Order 45 Rule 7 of the CI 47 has provisions dealing with what will happen after we have attached the property. This is what it says. Order 45 Rule 7 of CI 47. The court may at any time during an attachment under this order direct that any part of the property attached which consists of money or a sufficient part of it shall be paid over to the party applying for execution of the judgment. So if what we see included money, or a sufficient part of it, we can pay over that amount of money to the judgment creditor. And B, the portion which does not consist of money, so far as may be necessary for the satisfaction of the judgment, it shall be sold, and that the money realized by the sale or a sufficient part of it shall be paid to the party. So for example, if it is a car, if it is a house which is not money, For that one, it can be sold, and the money realized from the sale or a sufficient part of it shall be paid to the judgment creditor. Now, who is supposed to conduct the sale? If we have seized your property pursuant to a writ of Fieri, who is supposed to conduct the sale? The answer is in Order 45, Rule 8 of CI 47. It reads as follows: sales in execution of judgments shall be made under the direction of the registrar and shall be conducted according to such orders, if any, as the court may make on the application of any party concerned. Unless the court authorizes the sale to be made in any other manner, the sale shall be made by public auction. Again, unless the court authorizes the sale to be made in any other manner, the sale shall be made by public auction. So that if we have seized your property, like a car, like a house, remember that we seize everything because we want to recover money for the judgment creditor. If we seize it, the sale shall be by public auction. That is according to Order 45, Rule 8, Sub Rule 2. So you can't go and sell it at your own price. It shall be by public auction so that we get the right money for the judgment creditor. But there are some rules that govern the sale. Look at Order 45, Rule 9 of CI 47. It has very instructive provisions about how to conduct the sale because there are some required notices that you must give. So watch out for what I'm about to read now and take note of the notice we are supposed to give if we are going to sell a movable as compared to an immovable. By the time I finish reading Order 45, Rule 9, you should be able to tell the distinction between the timelines you have to do the publication for a movable as compared to an immovable. Order 45 Rule 9 reads as follows, and I quote: subject to Sub Rule 3 of this rule, no sale shall be made until after at least 7 days notice of the sale in the case of movable property, or in the case of immovable property until after at least 21 days public notice, unless the judgment debtor in writing consents otherwise. Usually you see these things in the Daily Graphic or Ghanaian Times. There will be a page, public auction. So between the time of the publication and the time when the auction is supposed to be done, if it is an immovable, there must be at least 21 days before you can carry out the auction. If it's a movable, there must be at least 7 days. So if you make the publication today, remember that you need at least 7 days before you can go ahead and carry out the auction. If it's a movable. But if it's immovable, you need 21 days notice before you can go ahead and carry out the auction. But of course, the rule says that unless the judgment debtor consents in writing that he doesn't want the 21 days notice. Order 45 Rule 9 Sub Rule 2. Whatever notices are made elsewhere, the notices shall be made in the town or place where the property to be sold is situated. And if the sale is to take place in any other town or place, the notices shall also be made at the place of sale. The court may, for any sufficient reason, extend or reduce the period of notice in any case. So I'm saying that if it's a movable, you need at least 7 days notice. And if it's an immovable, you need at least 21 days notice. What if the auctioneer does a publication and sells it on the 15th day, even though it's an immovable property? What is the remedy you have in law? Because we've been told that if it's immovable, you need 21 days. But because they're in a hurry, they do the publication and maybe 6 days, they go and sell. What is the consequence? Order 45 Rule 10 deals with setting aside for irregularity. And it reads as follows. At any time within 21 days from the date of the sale of any immovable property, again, at any time within 21 days from the date of the sale of any immovable property, an application may be made to the court to set aside the sale on the grounds of any material irregularity in the conduct of the sale. But no sale shall be set aside on the grounds of such irregularity unless the applicant proves to the satisfaction of the court that he has sustained substantial injury by reason of the irregularity. This is one of the most important provisions as far as this whole proceedings and procedure about execution is concerned. Because if your property has been sold, it's actually painful because this is your property you have and it's been sold. Meanwhile, the law has laid down a procedure for the sale to be carried out. When there's any irregularity, this is where you are going to come under. Take note of it. Order 45, Rule 10 of CI 47. It reads as follows: that at any time within 21 days from the date of the sale of any immovable property, an application may be made to the court to set aside the sale on the grounds of any material irregularity in the conduct of the sale. But no sale shall be set aside on the grounds of such irregularity unless the applicant proves to the satisfaction of the court that he has sustained substantial injury by reason of the irregularity. What I want you to take note of is this. It says that if you want to bring the application to set aside the sale in the event of any irregularity, you have 21 days from the date of the sale of the immovable property. Not only that, even when you bring it within the 21 days, when you bring your application within the 21 days, the only ground or the main ground you shall bring the application is a material irregularity. But even if you show that material irregularity, the sale will still not be set aside on the mere ground of that irregularity unless you, the applicant, you show that you have sustained substantial injury by reason of the irregularity. So take note, you have 21 days, but even if you bring the application within 21 days, the grounds must be based on a material irregularity. And even when you bring the application within the 21 days, we will still not set it aside unless you can prove that you have sustained some substantial injury by reason of that irregularity. Order 45 Rule 10 Rule 2. If the application is granted by the court shall make an order setting aside the sale for irregularity, and thereupon the purchaser shall be entitled to receive back any money deposited or paid by the purchaser on account of the sale, with or without interest, to be paid by such parties and in such manner as the court may direct. Again, if the application is granted by the court shall make an order setting aside the sale for the irregularity, and thereupon the purchaser shall be entitled to receive back any money deposited or paid by the purchaser on account of the sale, with or without interest, to be paid by such parties and in such manner as the court may direct. Because if I've come to buy the property, I've paid money into court, and now it has been set aside, you have to return the money to me. That is the import of Order 45, Rule 10 of CI 47. But what if you don't bring any application within the 21 days? If after the auction still has been conducted, remember we said that if it's an immovable, you have 21 days notice to give. So we give a 21 days notice, we carry out the auction, and you don't bring any application within 21 days to set aside the sale. What is the implication? You see, the sale becomes absolute. So look at Order 45, Rule 11 of CI 47. If no application is made under Rule 10, the sale shall become absolute. If it becomes absolute, it means that we are done with the whole process. So after the sale has been done, you have 21 days within which you can bring an application to set aside the auction sale. But if you don't bring the application within the 21 days, the sale shall end up becoming absolute. That is the import of Order 45, Rule 11 of CI 47. If no application is made under Rule 10, the sale shall become absolute. Then Order 45, Rule 11, Sub Rule 2. If an application under Rule 10 is dismissed, the court shall make an order confirming the sale. So there are two things. Within the 21 days, if you don't bring any application, the sale shall automatically become absolute. So if after the auction sale you don't bring any application within 21 days, the sale shall automatically become absolute. Alternatively, if you bring the application within 21 days and that application is also dismissed, so it rule against you, then the court shall then make an order confirming the sale. What is the implication of this? You understand why I'm saying this? Look at Order 45, Rule 11, Sub Rule 3. After a sale of immovable property becomes absolute or is confirmed under this rule, the court shall grant a certificate to the person who was declared the purchaser at the sale, to the effect that the person has purchased the rights, title, and interest of the judgment debtor in the property sold. Again, after a sale of immovable property becomes absolute or is confirmed under this rule, the court shall grant a certificate to the person who was declared the purchaser at the sale, to the effect that the person has purchased the rights, title, and interest of the judgment debtor in the property sold. Let me explain this. So Kofi has judgment against Amma. Amma's property has been attached and sold by the registrar. If the sale becomes absolute, then the registrar or the court shall then grant a certificate to the one who was declared the purchaser. So at the auction sale, the one who bought the property, Kwame, he shall be granted a certificate. And that certificate will confirm that he has bought Amma's property. So we don't even need Amma's signature. Even though the property belongs to Amma, the sale was done by the court. So the court is the one that will give the certificate of transfer to the purchaser. So we usually call it certificate of purchase. So if you go and buy an auction property conducted under the instructions of the court will order, and then the court will then issue a certificate of purchase. So that's what Order 45, 11, Sub 2 is saying. That after a sale of immovable property becomes absolute or is confirmed under this rule, the court shall grant a certificate to the person who was declared the purchaser at the sale, to the effect that that person has purchased the rights, title, and interest of the judgment debtor in the property sold. Then Order 45, 11, Sub 4. A certificate of purchase granted under Sub Rule 3 is a valid transfer of the rights, title, and interest of the judgment debtor in the property sold. Once the court issues the purchaser with a certificate of purchase, it's a valid transfer. We don't care whether you, the judgment debtor, you have signed anything or not. We don't care about it. It's the court who did the sale. So if the court grants a certificate of purchase, then that ends the matter. So a certificate of purchase granted under Sub Rule 3 is a valid transfer of the rights, title, and interest of the judgment debtor in the property sold. Then Order 45, Rule 12 of CI 47, dealing with delivery of property sold. It reads as follows. Where the property sold consists of movable property in possession of the judgment debtor, or to the immediate possession of which the judgment debtor is entitled, and of which actual seizure has been made, the property shall be delivered to the purchaser. Where the property sold consists of movable property in possession of the judgment debtor, or to the immediate possession of which the judgment debtor is entitled, and of which the actual seizure has been made, the property shall be delivered to the purchaser. So if it's a movable, and then we go ahead and we carry out the sale, we shall deliver the movable property to you. When we issue the writ of Fieri, how long does it last for? How long does the writ of Fieri last for? The answer to this question is under Order 44, Rule 9 of CI 47. It says that for the purposes of execution, a writ of execution shall be valid in the first instance for 12 months, beginning with the date of its issue. For the purpose of execution, a writ of execution shall be valid in the first instance for 12 months, beginning with the date of its issue. So once we issue the writ of Fieri, we have the 12 months to go and execute it by seizing the property. Sometimes you issue the writ of Fieri, you are not looking for properties, you don't find it. If you don't get the properties within 12 months, please, your writ of execution has expired. Take note, once the writ is issued, you have 12 months to execute it. So if you issue the writ, you go around and you look for the properties, you don't find it. The writ expires. When it expires, what is the implication? Order 44 Rule 9, Sub Rule 2. It reads as follows. Where a writ has not been executed, the court may by order extend the validity of the writ from time for a period of 12 months at any one time, beginning with the day on which the order is made. If an application for extension of time is made to the court before the day on which the writ would otherwise expire. Where a writ has not been wholly executed, the court may by order extend the validity of the writ from time for a period of 12 months at any one time beginning with the day on which the order is made, if an application for extension of time is made to the court before the day on which the writ would otherwise expire. I'll wrap up this lecture by reading the words from the case of ACA versus Ghana Commercial Bank, reported in 2013-2014 Supreme Court of Ghana Law Report at page 1157, which reads as follows, and I quote, "The effect of the writ of Fieri in law is to bind the property of the judgment debtor." I'll take it once again. That the effect of a writ of Fieri in law is to bind the property of the judgment debtor if the writ is enforced within 12 months when a property is attached. The implementing process like valuation of the property, application to the court for reserve price under the auction sales law, and any other advertisement would follow. If the property is attached beyond the 12 months without any valid renewal, the writ will be valid in law. If a writ of Fieri is executed by the bailiff attaching the property within a year of its issue from the registry, it is valid. The other procedural formalities referred to above may take years, but the writ of Fieri would not be invalid. End of quote. Let me explain this. The writ is what is valid in the first instance for 12 months. So if the writ is issued and then the property is seized within that 12 months, the other procedural steps like applying to the court for reserve price, like going to look for buyers, publishing, all those things can be done after the 12 months. But the writ itself must be executed within the first 12 months. You must seize the property within the 12 months. And once that is done, every other thing can go beyond the 12 months. This is where we shall draw the curtains in our lecture as far as execution of a judgment by writ of Fieri is concerned. In our next lecture, we shall deal with the instances whereby a judgment creditor would go ahead and seize property thinking it belongs to the judgment debtor, meanwhile it belongs to some other person. For example, I seize property belonging to a defendant, meanwhile it rather belongs to his father, it belongs to his nephew, it belongs to his friend. What is the implication and what does the law say about that? So in our next lecture, we shall be dealing with interpleader proceedings, and we shall deal with in extenso what the law says about such proceedings. Thank you.